Hello, my name is Romy Thorn, and as Group 10 we will give our presentation about the 1984 Bhopal gas disaster. I will start with an introduction about the disaster and what happened. Then I will follow with the structure and decision of why to go to India of Union Carbide Corporation. After that, the social cost will be discussed, the safety and industrial regulations will be discussed, separated by those standards in the US and India, and the efficiency of the efficiency of these standards. Then the aftermath will be discussed, the new regulations that are being adopted after the disaster, and I will end the presentation with a conclusion. To start with the introduction, in the night of the 2nd to the 3rd of December 1984, over 45 tons of methyl isocyanide, or MIC, leaked into the atmosphere, leading to over 15,000 people being killed right after the disaster, and more than 500,000 people who survived the disaster suffered from severe illnesses or disabilities. Even further in their lives, they were not able to find a job, they were blind, they had problems breathing, and some of those people are still alive, but most people died already. After the leak in 1989, Union Carbide Corporation, or UCC, settled with the Indian government for $470 million US. After that, multiple cases were brought to the US court, but they were all dismissed because a settlement was already reached. And there was a regulation adopted after the disaster that only the Indian government could represent all the victims of the gas disaster. Then the structure of UCC and why they went to India. UCC was incorporated on the 1st of November 1917 from a merger of different companies. They had UCIL, Union Carbide India Limited, as their subsidiary company. They were 50.9% shareholder, and the other 49.1% shares were owned by the Indian government through Indian government owned banks. This was based on the public policy to prevent large American companies or foreign companies to take over the complete Indian economy. The UCC decided to set up this pesticide plant in Bhopal, India, based on numerous decisions. They wanted to increase their economic efficiency of the company, and by doing this they also used the Calder-Hicks efficiency. They took the risk to increase their own welfare of the company by decreasing the risk of other people, so the people in Bhopal living around the factory and working at the factory. This led to Calder-Hicks efficiency because there was a hypothetical compensation taken into account for certain environmental damages, or in case compensation needed to be paid when an accident happened. However, the accident actually did happen, so there was also Pareto efficiency because the compensation was eventually paid. It was not everything that the survivors wanted, but compensation was paid, so there was Pareto efficiency. Coase theorem also applies, since the value of the operation of the pesticide plant in Bhopal was higher than the possible accident compensation or environmental damage compensation that had to be paid by the company to the people who lived near it. Furthermore, the shares owned by UCC of UCIL were sold in 1994 following the disaster, and UCC itself became a subsidiary of the Dow Chemical Company in 2001.
Hi, my name is Mohammed Ali. And in this part of the presentation, I will talk about the social theory of the social cost and how the theory is related to the Bhopal disaster. Social cost in neoclassical economics is the sum of the private cost resulting from a transaction and the cost imposed on the consumers as a consequence of being exposed to the operation for which they are not compensated or charged. In simple words, we can say that the social cost is a cost which is borne by society or which is suffered by the society. According to this theory of the social cost, producers shift as much cost as they can towards society in order to increase profits. Because social cost is a systematic and not an accidental phenomenon, systematic planning is necessary to prevent it. This means the adoption of the precautionary principles and a reversal of the burden of the proof, such as that the producers have to prove the safety of the production methods and products beforehand. The social cost of the Bhopal tragedy, we can say sadly, was far more significant, and the people of the Bhopal bore the cost of the Union Carbide gross negligence. Social cost involves triggering events and subsequent crises which causes large damage to human life and the natural environment. They also create an unknown risk to the public which further enhances perception of damage. And the damages can be of two types: damage to the life of the person and damage to the environment. Damages to life include death, injuries, delayed health effects, and health effects on the future generation. Environmental damages include the destruction of vegetation, pollution of air and water, and soil changes in weather patterns, mutation of natural life, species, etc. High economic and social costs characterize an industrial crisis such as Bhopal crisis or Bhopal tragedy. Organizations that own facilities where crisis originates are held legally liable for compensating victims for damages. Social costs of crisis are high because they involve disruptions in social, political, and cultural arrangements. Crises are associated with large-scale evacuation of personnel, rehabilitation of affected persons, and sometimes reorganizations of family interdependencies. Social conflicts over consequences of crisis create political disruptions within a community. Crises lead to the questioning of legitimacy and the social order and demands for fundamental changes in the social system. In concluding my part of the presentation, I would like to state that the Bhopal tragedy created a substantial social cost which was mainly borne by the society. By society, I mean the people of the Bhopal, not the government and not the Union Carbide. It was the society who suffered the most. For example, the social costs of the disaster include two significant evacuations of the city, which was around 200,000 to 400,000 people, business losses up to $60 million, and as a result of the tragedy, Union Carbide and the Indian government, they both were sued because of this crisis. Thank you.
Good afternoon. My name is Christina Nicolai, and I'm going to discuss the decisions made by Union Carbide Corporation, which led to build the path to the 1984 Bhopal disaster. If we go back a few years before the accident, we should note that there has been several external factors which, in the end, determined the Union Carbide Corporation to prepare the plan for sale in July 1984, so 6 months before the accident. Those external factors were, for example, a weak demand for the pesticides produced by the Bhopal plant. Plant was producing at a third of its capacity, which eventually resulted in a loss of $4 million supported by the Union Carbide Corporation. All of these aspects led to the cost-cutting syndrome, which involved at first a backward integration in Bhopal. So instead of importing the MIC gas from the US, it was produced in Bhopal. And a year prior to the disaster, several decisions have involving, for example, disconnecting a refrigerating system designed to keep the stored MIC gas at a temperature of 0 degrees, as well as replacing damaged stainless steel pipes with ordinary carbon steel pipes, resulted in a malfunctioning of the plant overall. What is also very interesting to note is that there have been four previous leaks between 1980 and 1984, which resulted in respiratory problems and watering of the eyes of the affected persons. However, they were not dealt with properly. Now, to better understand the decisions made by the company, we should take a look at the economical considerations. So, if we talk about voluntary agreements, those usually generate benefits by mutually satisfying the contracting parties' preferences. So, people contract because doing so would yield expected benefits ex ante. However, most agreements allocate a risk, and sometimes the harm is the ancillary side effect of an action. So if we consider that scenario, we should ask what should be the pertinent rule of decisions when there are conflicting preferences between the parties. And we should look at the practical example that we have with the Union Carbide Corporation and the applying the Coase theorem. We should think that in a world where bargaining is free, all affected parties would have agreed upon maximizing their collective well-being, even if the outcome would appear to render some of them potentially worse off ex post. The reason why they would do so is because the benefited parties could still compensate the people whom the policy decision negatively affected, and yet still be better off than they were ex ante. The case at hand, it's a very good example of a Calder-Higgs efficiency, otherwise known as a potential par to improvement, which arises when an action increases the net welfare of the society but harms at least one person. In those circumstances, the parties benefited from the arrangement could compensate the injured people and be better off ex post, which is exactly what happened with Union Carbide Corporation after the disaster, as well as the Indian government in terms of economical aspects. And this concludes my part.
My name is Ruben Angwerder. I'd first like to share some basics on this topic. Firstly, we all understand efficiency. It's in our very natures. In simple terms, efficiency is best described as making effective use of time, money, and resources. A key concept here is the Pareto improvement. Although not clearly apparent on the surface, this neoclassical economic rubric, the Pareto improvement, goes to the very heart of this tragedy. The Pareto improvement is such that an economic action, when applied, has a net welfare gain to a single actor without making any other actor worse off. And what we see here from this report is that this rubric was not met and shows significant disproportionality. In the context of efficiency and Bhopal, there are really two sides to this equation. On one hand, we have the Union Carbide Corporation, who has shareholders and operates with the intention to profit. And on the other hand, we have the poor inhabitants of Bhopal, who have borne the brunt of this toxic disaster and suffered greatly. Efficiency in this context detaches itself from morality and ethical considerations. What then is an official legal proceeding, and how can that be achieved? Ultimately, an efficient legal proceeding would be achieved without the need for any outside adjudication, basically where parties solve this for themselves. However, where that's not the case, legal efficiency has two basic premises. First, that a legal system is cost-effective to render engagement to all parties irrespective of their affluence. And secondly, procedural efficiency, getting justice out as quickly as possible to solve the outcome in the least amount of time. The balancing act here, in which we have a global chemical manufacturer who has left a toxic wasteland behind its economic decision making versus the pile of dead and suffering on the side of the victims. The ultimate goal of any legal system will be some form of restitution, even if that outcome only equates to becoming second best. The realities of the case. What happened to the legal fallout of Bhopal? Well, the initial response was a distancing from the culpability. The company placed all the blame on the Indian subsidiary, which was in part owned by the Indian government. Then the company became locked up in proceedings that related to the issue, yet were not representative of the victims. The Indian government stepped in, declared itself the sole representative of the victims, which led to a judge placing the entire case in the hands of Indian jurisdiction, much to the detriment of the injured parties. Soon after dismissal, a settlement was reached between the parties of about $470 million US. As soon as this settlement was reached, Union Carbide Corporation withdrew operations immediately, not even cleaning up after the fact, as this picture illustrates. What is an effective legal outcome? In reality, the analysis made in 1985 suggests not. This report spelled out that at the time, precedent in the US as far as payouts for asbestos showed a serious disproportionality. The value of the case and the liable would have been more than $10 billion US, which at the time was more than what Union Carbide was valued. Funnily enough, as soon as the settlement was reached, the share price rose 7%, reflecting both the boon and the outcome, and the boon that the outcome achieved for the company. So from the perspective of Union Carbide, this was an inefficient outcome. The cost of the liable was far below anything previously rendered. The company was able to save its name by deferring blame and opening up arguments of conjecture, withdrawing from the subcontinent with no strings attached, and leaving their management board free of criminal charges. However, a lot more can be said about what the victims received for this tragedy. The settlement brought the cost of life down to a measly sum of $2,000 US. This concludes my part.
My name is Natalia Sabova, and I'm going to talk about the legislative developments after the Bhopal gas tragedy. This tragedy is a perfect example of a Pareto efficiency, where welfare of one individual cannot be improved without reducing the welfare of others. In this example, the Indian government took the risk and tried to boost and improve their economic development and started industrialization in a densely populated area of Bhopal. However, by this action, they put lives of many people in danger. And not only the Indian government, but also Union Carbide Corporation tried to improve their wealth, but on what cost? By risking lives of many people, which suffer to this day as the environment never been cleaned. Following this disaster, the Supreme Court of India in 1989 reached the settlement mentioning that Union Carbide Corporation was to pay $470 million US as a full and final settlement for all civil and criminal claims. Not much later, after the disaster, the Indian government passed a Bhopal Gas Leak Disaster Act, under which a scheme was created that was supposed to help victims and the courts with registration, processing, and the determination of each claim. It needs to be mentioned that when Indian Constitution came into the being, at the time and during the time of the disaster, there was no direct provision related to protection of environment. So this can be considered to be one of the reasons why the government decided to cooperate with the Union Carbide Corporation and why the disaster happened and why they did not protect the environment. They ignored everything and they put the lives of people in risk. So as an immediate reaction to the disaster, the Environmental Protection Act was created and came into force. Until now, this act is referred to as an umbrella legislation, as it covers almost all dimensions relating to the environment. The act also empowers the central government to take all measures that deem necessary for the purposes of protecting and improving the quality of environment, also preventing and controlling environmental pollution, and also preventing future disasters and tragedies. In relation to this Environmental Protection Act, the Supreme Court of India laid down a foundation for environmental courts in India. They are referred to as national green tribunals, and these courts are dealing with environmental issues and claims. And lastly, as a reaction to the tragedy, in 1991, Indian government passed the Public Liability Insurance Act, which is intended to provide immediate relief to the victims affected by accidents, which happened during to the victims which are affected by accidents while handling hazardous substances, and also to any matters connected with such substances and such matters. So it can be considered and concluded that the decisions of Indian government were based on economic considerations. They wanted to improve economic development of their country. However, the risk they took was too high, and many innocent people suffered and still do suffer. The legislation passed after the tragedy aimed at compensation of the victims and preventing such incidents in future, and also protecting the environment. However, it cannot be forgotten that the social cost of the Bhopal tragedy was very significant for the people of the Bhopal and for all India, and they have to bear the costs, and the people of the Bhopal have to bear the costs taken by Indian government and Union Corporation.
Well, this is Romy Thorn again. I will end the presentation with a conclusion. UCC, as seen in the presentation, or UCIL, willingly took the risk to set up a pesticide plant in Bhopal, India, in an area where a lot of people lived. They took this risk to increase the economic efficiency of the company. Furthermore, there was a high social cost involved in the accident, many people killed, a lot of people who survived, or most people who survived, suffered from severe illnesses or disabilities for the rest of their lives. They were not able to find jobs anymore, so could not be economically independent anymore. The Calder-Hicks efficiency and Pareto efficiencies apply. They took the risk. There was a hypothetical compensation in case of environmental damage. Then or in case of an accident, the accident actually happened. So the hypothetical compensation was paid. It became Pareto efficiency. Coase theorem applies since the value of the pesticide plant was higher than the cost that should be paid in case of an accident to the people living nearby. And there were new regulations adopted after the Bhopal gas disaster. However, these regulations are not followed up by. The government does not do enough to prevent accidents like this to happen, and most people still think that this will happen to somebody else, but not to them. This leads to the fact that accidents, they are smaller than the Bhopal accident, but they continue to happen.